All right, welcome in, everyone. We see the queue growing. Welcome back to those of you who have been to our artist resource series before. If this is your first time, welcome. We usually end up getting started around 6:04, 6:05. Give people an extra couple minutes to get ready. So I'm Christian Anderson. I'm the executive director of LVA. Thanks for being here. So again, get yourself comfortable, get a tea, a coffee, or whatever, and we'll get rolling in a couple minutes.
Yeah, I see a lot of people I know.
Oh, good.
Yeah. You probably know a few of them. Kyle.
I might.
Yeah.
Hi, folks I know.
Kit Tossman, there you go. His husband, Jurgen, runs Bunbury. Or I think he's kind of semi-retired, but not quite out of it. Which is what happens in the creative world.
Oh.
Hannah DeWitt. Mary Dennis is here. I know you know her, Kyle.
Yeah.
Yeah.
Well, good.
Megan Bickle. Yeah, lots of cool people are in.
Gang's all here. Awesome.
Yeah, we'll give them a couple of minutes more. I'll go ahead. Some of you know this from previous times, but if you have questions that come up in your mind, or you already have questions now, we ask you to enter them into the chat or the Q&A, and I will monitor that. And certainly at the end, we'll have a Q&A period. If I see a question that I think really seems to feed into what Kyle is talking about, I might bring it up. But we would definitely plan on having kind of a Q&A session when she's done with her presentation.
Hannah, I see your question. You are really the first. There's someone who sent a direct the felicitations to Keith was sent in a direct message, but the chat is working. No one has typed anything other than you in it as of yet. So.
And that's fairly typical. I'm sure everybody has lots to say.
All right, maybe just one more minute, and then we'll get rolling. As Keith said, any questions that you have throughout the course of Kyle's presentation, feel free to drop them in the chat or Q&A, and Keith will be summarizing all of those. Oftentimes we see similar questions asked that we can sort of synthesize into one. I guess I will say howdy and get rolling. So again, my name is Christian Anderson. I'm the executive director of Louisville Visual Art. Thanks everyone for being here for our 6th artist resource session. And I want to thank Brook Smith for underwriting these classes. I think, fingers crossed, this is probably going to be the last virtual session that we'll be doing. Hopefully we'll be moving to in-person sessions in March or April. But we're working on the logistics and keeping an eye on that. So we aren't 100% ready to sort of introduce our March topic and session yet, as we're trying to sort of wait for some of those in-person things, but keep your eyes peeled to your email and or social media, and that will be out. I want to thank Keith for always being the consummate moderator and host of these sessions. And lastly, I want to thank Kyle Citrynell. Kyle, welcome back. For those of you who have been to all of our sessions, Kyle kicked off the very first one with the introduction to copyright, and it's great to have her back, for episode 6 in talking about contracts for artists and what artists need to know. So without any further ado, thanks, Kyle, and take it away.
Oh, thank you.
Yeah.
Okay, well, hi, everybody. For those of you who know me, I'm an attorney. I'm a partner at Seiler Waterman. We're a general practice law firm, and I head the intellectual property group at our firm. I have been practicing law for 41 years, actually going on 42 pretty soon. And I have a practice which involves national litigation and transactional practice in arts, entertainment, media, publishing, and technology, which frequently touches on intellectual property. I have done hundreds of intellectual property cases, copyright infringement and related cases. And many of those involve contracts, and many other cases are just standalone contract cases. I've touched thousands, I was just trying to rough it out in my head, thousands of contracts in the that relate to creative industries. In my career, I've done licensing and merchandising and distribution, franchising. I've done work for inventors and artists and film and event producers, performers, musicians, artists, authors, magazine and book and website publishers, and software and multimedia creators and radio and television shows. So there are a lot of different types of contracts I have touched and seen in my career. I typically start these programs with some information about the industry that the participants are involved in. And you know, you guys are in the arts industry, which is really a copyright-centric type of industry, because copyright protects expression. What we're going to do this evening is talk a little bit about contracts and how they're positioned in the economy, and particularly in your industry. We're going to talk about contracts in general, contracts that are specific to intellectual property issues, and then we'll go through just some contract provisions. I culled a variety of them, and we'll run through them. I'll show you some different things, different ways of treating different kinds of subjects. And then I want you to come away from this thinking about contracts as more than just a honey-do list, you know, more than just I'll do this and you'll pay me that. Contracts are quite important strategically, and they can follow you from one end of your career to the other. So we can talk about that. So let's start with talking about copyright and and the intellectual property industries, and just how enormous they are. $6 trillion of the United States GDP, 45 million jobs, exports over 218 billion, you know, just a constantly growing sector of the economy, larger than electronics, appliances, pharmaceuticals, medicine, agriculture, or aerospace. And every single one of those dollars that is exchanged in that industry, there's a contract behind it. In the IP world, particularly in IP, intellectual property, licensing is an enormous business. Licensing is one of those commercial transactions that is guided by contract. And you can see that the licensed merchandise and services is also just a wildly enormous industry, close to $3 billion. And, the arts alone represent close to $300 billion. And then arts alone represent $3 billion, entertainment and characters is more like 128 billion. The nonprofit sector of the art world, 1.3 billion. So, and once again, and I don't mean to be, or maybe I do mean to be redundant, but every one of those dollars is backed by a contract that controls how that license takes place. Piracy and counterfeiting are also huge businesses. We don't really need to dwell on this. Contracts can be an important piece for you in plugging holes so that you are not the victim of counterfeiting and piracy, or that you have means of redressing that. Artists and creatives are close to 3.5 times more likely to be self-employed. You guys really are small businesses, and these are some statistics about contracts and small businesses. So you can see 36 to 53% of all small businesses will get sued in a given year. Over 30% of those suits will be about contracts. And the cost of a suit, around $91,000. So that's a median, and eggs are cheaper in the country, but nevertheless, a lawsuit can be an extremely time-consuming and expensive proposition. And given the likelihood that there will be a contract dispute, and given the cost of litigation, it becomes well worth it to document deals and make sure you understand what you're signing. Make sure that your contracts are good, that they are clear, that they're drafted to identify and allocate risk, and that you consider what could go wrong in your relationship and you prepare for it with your contract. Similarly, copyright cases, very expensive proposition, largely because of the time involved, but also because of the experts involved. So since intellectual property interfaces your businesses and your contracts at every turn, and even contracts that don't seem to relate to your intellectual property may touch it. For example, when the Small Business Administration gives you a loan, they take a lien against your intangible rights. Well, your intangible rights are your intellectual property rights. They're your copyrights and your contracts. I mean, your copyrights and your trademarks, your patents. So even in contracts that don't seem to relate to intellectual property, those contracts could very likely do interface with the intellectual property considerations that affect your business. Now, tonight is not a seminar on intellectual property, but I did want to just run through a refresher course on sort of the high points, because these points affect and frequently are drawn into the drafting, negotiation, and quite frankly, understanding and reading contracts when they're put in front of you. So let's start. Copyright is the pivotal right for artists. That is not to understate the importance of trademarks and patents and trade secrets and publicity rights, all of which we're going to cover in a minute. But copyright is the quintessential artist's right. Copyright is an exclusive bundle of rights. And those of you who have been to my lectures before have seen this lovely broom. I intend for you to walk away remembering this broom, probably above all else. Copyright and other intellectual property rights are like bundles of rights. If you can imagine what an intangible, a right you can't touch, looks like, if you could touch it, it would look like a broom that is comprised of many straws, and those straws are the individual rights that can be broken up and manipulated in these commercial transactions or through contracts in a variety of different ways. So very important, if you are engaging in or entering into a contract that relates to any copyright, you want to speak only to the rights that copyright embraces. Copyright gives the owner of copyright the exclusive right to reproduce, to prepare derivative works. So that's to go from English to Spanish, to go from a script to a full-blown movie, to go from a two-dimensional cartoon to a stuffed animal. Those are derivative works. Copyright owners have the exclusive right to distribute, the exclusive right to perform publicly, to display publicly, and to transmit. And all of those rights can be affected through your contractual dealings. Copyright owners also have the exclusive right to import. The word exclusive is a very important word when you're in the contract realm. Copyright owners have this bundle of exclusive rights. When you enter into a contract and you grant somebody else an exclusive right, you are by definition excluding yourself. Exclusive has one operator. So if you give somebody else the exclusive right to distribute your work, you cannot distribute your work. If you give somebody the exclusive right to display the work publicly, you cannot display the work publicly unless you arrange in the contract for some kind of exclusion or some definitional work that clarifies that situation and keeps you in the game. So for example, do you want to be able to include your works in your portfolio after you give away the right to display? You probably do. Well, you need to include, if you've given somebody the exclusive right to display, you need to set up in your contract the right to include it in your portfolio so that you have that right. This is the bundle of copyrights. These last your life plus 70 years. And that means that those rights are going to live longer than you, and you will have documents in your life, contracts, that should speak to the disposition and how you want those rights handled after your passing. Copyright protects, as I've said, expression. It protects original expression. We're not going to go deep into that. Originality is a very low threshold. It means owes its origin to the author. There can be more than one author. If you have a co-author or anyone adds work with the intention that the work be merged into an inseparable piece, so words and music and lyrics, things that go together, some kind of textual work with illustrations, works that are intended to go together, you will have a co-author. It is possible that the authors will not contribute equally. Copyright law says all authors are equal unless they agree in writing to vary that equality. So if there are two authors, one has done 90% of the work and one has done 10% of the work, without a contract, they are 50-50 owners of the rights in that work. You need a contract to change that. Only humans can be persons. In fact, just this week, the Copyright Office issued a regulation saying that that artificial intelligence cannot produce copyrightable work because it's not created by a human. In addition to that bundle of rights, copyright also protects visual artists' moral rights, and it protects two specific kinds of moral rights. One is the right of attribution or paternity, which means you have the right to claim or deny ownership. And the other is the right of integrity, which means that you have the right to prevent the destruction of your work. Now, the Visual Arts Rights Act, VARA, is specific to works of visual art, paintings, drawings, sculptures, still photography, in signed numbers edition up to 200. It only lasts the life of the artist. It is not applicable to work made for hire, and that can be very important in a contractual arrangement. So I mentioned that. We'll talk about work for hire in a second, but if you want to preserve your VARA rights, you have to do it as an individual and not through an entity. It's waivable, but not assignable. And we'll talk about VARA waivers, which are one of the kinds of documents that have to be in writing a little later. So work for hire, we mentioned work for hire, and work for hire is, it is an important part of the copyright scenario. And once again, one which bears keeping in mind in connection with the kinds of contracts that you are likely to have to deal with. So in the business, the creative business, if the author, the artist, the creator, as we've discussed, owns the copyright bundle. If the creator is an employee working within the scope of their employment, meaning that creation is part of their job, then the work prepared by the employee belongs to the employer. For other works that are created by independent contractors, they only applies to 9 categories of work. So there are only 9 categories of work that can become work for hire. And those are contributions to a collective work. So that's like an anthology, part of a motion picture or an audiovisual work, a translation, a supplementary work. So that's illustrations that go with text or text that goes with illustrations, instructional texts, tests, answers to tests. The test industry was in the room when this draft was drafted. An atlas or an atlas. Work for hire agreements must be in writing, and work for hire agreements must use the magic words work made for hire. One of the things that's interesting too, and we're not going to talk too much about the cases, but I do want to talk to you because we'll talk about law fixes and jurisdiction fixes in contracts. And that won't mean much to you unless I mention this. So if you'll look in the corner, there are 2 cases. One that says that a work made for hire document has to predate creation, which means it has to come before the work for hire is done. And another case that says, oh, no, it can be after. This is why picking the law that's applicable to your contract can be so important. The Seventh Circuit covers Illinois, Indiana, and Wisconsin. And in those states, your work for hire agreement must predate creation. The Second Circuit covers New York, Connecticut, and Vermont. And they have a very different way of approaching work for hire agreements. So when you get to the end of your contract and you're reading the thing that says this contract will be governed by the law of X state, those are the kinds of provisions that can be affected by what law your contract says is going to control. The difference between intangible rights and tangible objects is also very important in your contracts. Intangible rights are the copyright, the bundle. We'll talk about trademarks and all these others, intangible rights. The tangible object is the thing that you can touch. The first sale doctrine says that when you sell your work, you are granting to the owner the right to display. Remember, that used to be your exclusive right, the right to display publicly. And they now own that work, the tangible work. They have not acquired the right to reproduce. They can't take your work and put it on calendars. They can't put it on T-shirts. They do not have any other rights. What I want to point out here, though, is that once the physical object is in their hands, you may or may not have rights to the physical object. So once again, your contract needs to be quite clear. If you want access for any reason, photographing, if you have a retrospective later on in your careers, your contract needs to say that you are going to be allowed to get access to it. Okay. So we'll move through these other IP rights quickly. Trademarks are any source identifying indicia, so words, names, symbols, trade dress, so the way that a package looks or the way that a product is created. Some jewelry companies where they use different kinds of things, a little garnet in every single piece of jewelry. Trade dress, the most famous trade dress in the world is our very own Maker's Mark red wax. Those things are, indicia that are a way that consumers can identify the source of goods or services and their sponsorship. Your business goodwill is entwined with your trademark. Trademarks are frequently subject to contract rights. If you are licensing a trademark, you must control the quality of the use of the trademark, so how the mark itself appears, but you also have to control the quality of the good or service to which the trademark is being attached, or you risk abandoning your trademark rights. And we'll talk later about quality control provisions, but that is why those provisions appear in those kinds of contracts. Patent rights, that's another one of the types of intellectual property rights. Again, let's talk about what bundle of rights goes with patent rights. Patents are make, use, and sell. One of the frustrations for me reading contracts frequently is that copyright licenses that use the word use, instead of I'm licensing you to reproduce. There is no copyright right to use. The bundle of copyrights we reviewed before. It's reproduction and display and performance and transmission. It's not use. Trademark rights include use. Patent rights include use. Trademark rights include use. And so it's important to make sure that that these contracts are that there's clarity in the choice of words, because ambiguity and mistake can cost a lot of money cleaning up a contract. And we'll talk a little bit about that too. So interestingly enough, with copyrights, co-authors, one co-author can go off, again, unless you have a contract that says otherwise, and enter into a transaction related to the copyright bundle without the consent of the other copyright owners. But they have a duty to account. In the patent world, one inventor can assign certain rights or grant certain rights to the exclusion of the other and has no duty to account. Contracts can be very, very important. Trade secrets, also an intellectual property right, and one which really requires attention through contractual dealings. I bet everyone on the phone has either seen or has already got in their drawer a non-disclosure agreement or a confidentiality agreement. Trade secrets can be any of these various kinds of information that are valuable to your business because they are not known or generally knowable and that you have taken efforts to protect. It's the efforts to protect prong that requires some kind of agreement to protect. You know, again, I hate to use my jokes over and over again, but Ben Franklin was so smart. A secret can be shared by 3 people if 2 are dead. Okay, so that's, if you have a non-disclosure agreement, then you can share secrets. In the copyright world, ideas are as free as the air. Ideas can only be protected through non-disclosure agreements. So that's a type of contract that you will frequently be exposed to. In the trade secret arena, you have to, at a minimum, put the person that you are sharing the secret with on notice that they are receiving a secret and put them on notice that they have a duty to protect the secret. There's also the right of publicity, and that is like a trademark right. In Kentucky, it covers the name and likeness of public figures for commercial exploitation. So that's, you know, using it in brands or, you know, to promote sponsorship, to suggest an association with, even to just reproduce a famous person in some kind of work. So that these vary from state to state, and they're controlled by the state where the person died. All righty. So contracts that involve intellectual property are really just contracts. A lot of lawyers glaze over because intellectual property brings with it a lot of different kinds of considerations. But contracts is one of the linchpins of the practice of law. It's one of the linchpins of conducting business. Contracts are ubiquitous, and they can arise out of words, whether they're verbal or written, and it can arise out of conduct. So, you know, it's very, very important to recognize that you are going to, that you're making contracts all the time. Because intellectual property touches your business so directly, when you are considering your own activities in your business. I tell my clients, design to protect. Think about all those rights that you have or could have and try to maximize your protection. I tell my clients to buy or hire to minimize risk. So you want to be sure that when you're acquiring third-party rights that you're getting them from someone who can give them to you, for example. The same is true of contracts. If in the arts business or the creative business, you need to be thinking about your intellectual property rights even as you're entering into a contract or discussing a contract, so that you are understanding from the get-go how this contract or the transaction you're about to undertake could impact your intellectual property rights. Contracts, like I said, linchpin of the practice, linchpin of the transactional world. An agreement that creates an obligation to do or not do something. You can have it in words, or it can be inferred from conduct. Now, this is the part where I want to start talking about promises that aren't in writing and conduct that suggests an agreement. Those kinds of situations are the most likely to end up in a dispute. And when that happens, you will be going to court and having a judge or a jury trying to interpret what they think you meant. A good way to avoid someone else trying to read your mind is to put it on paper. And then they don't have to read your mind unless the document is a clumsy document. And by that, I mean a badly written document that creates ambiguity, that perhaps one of my pet peeves is uses multiple terms for the same thing. If your contract is about a piece of sculpture, call it the work, call it the sculpture, but don't also call it the project, the materials, the object, because using different terminology for the same thing creates ambiguities in contracts that you then may have to go to a judge to unscramble. Contracts at their basis level are an offer, an acceptance, consideration, which is some kind of compensation, although it can also not do something. In a non-disclosure agreement, consideration is frequently the promise not to disclose your confidential information. And then meeting of the minds, meaning that the parties actually know what they're agreeing to and agree to it, that they understand what they're agreeing to it. Many contract cases are about mistake. Sometimes it's unilateral mistake. One person didn't understand. Sometimes it's bilateral. Both people didn't understand. Contracts require a meeting of the minds. They also require capacity. So that means that the person signing has to be of sound mind, or if a person is signing for an entity, must have the authority to sign for that entity and bind it. And they must be legal. So you may have a contract to do illegal things, but you can't enforce it. Contracts are interpreted based on the four corners of the document, meaning if a contract is clear, then the court will not go outside the actual document to figure out what the parties were saying. That is a very helpful thing. If it is unclear, the court will start considering what's called extrinsic evidence. And extrinsic evidence is that all those emails that you exchanged, any brochures, sales materials, advertisements, things that look like promises but aren't in the contract, but may have been the basis for or maybe useful in clearing up this unclear point. That would be in cases like, as we discussed, mutual mistake, ambiguity. Sometimes there's a separate agreement that actually controls and not the agreement that you're fighting about. Or extrinsic evidence can be considered if you were, forced or defrauded into entering the contract. The ambiguity piece is so important. Ambiguous contracts, you can go to court and have a judge construe the agreement for you. It can be a very useful device. And although I like to keep people out of litigation, and I like to use contracts to keep people out of litigation, if there's an ambiguity in your contract and you're having a dispute, frequently using that ambiguity to get to court will be the way to resolve the dispute. Either by not having to go to court, by settling, remember 99% settle, or by having a judge take care of it for you. Some contracts have to be in writing. And in Kentucky, these are the kinds of contracts that must be in writing. So if you are, if you're going to facilitate somebody else obtaining credit, or let's go through it. If there's a promise to help a third party get credit, that has to be in writing. If there's a promise to pay a debt incurred in infancy, it has to be in writing. If there's a promise of a personal representative, so somebody who's handling an estate, to pay a liability of the dead person, it has to be in writing. Contracts, anything where you're agreeing to take care of somebody's debt or misdoing must be in writing. Contracts for marriage, writing. Contracts related to real estate, writing. Contracts that can't be performed in a year, in writing. Now, that's one of those funny places that lawyers fight all about. The idea that I'm hiring you for 5 years to tend to my garden, and but the contract could terminate in a year if you die. That may or may not be the kind of thing that has to be in writing, because it could be performed in a year. Similarly, the promise to loan money to assist somebody in establishing a business is also something that has to be in writing. So those kinds of contracts, you don't have, if you want them binding and enforceable, you need them in writing. Similarly, in the copyright and IP realm, certain kinds of documents must be in writing. A work for hire agreement has to be in writing. An assignment of rights, and an assignment is like, in the IP world, an assignment is like a deed. So when you assign, you can assign all or part of your rights to someone else. that assignment must be in writing. Anytime you have an exclusive license, and remember what we talked about, what exclusive means, exclusive rights must be defined in writing. And VERA waivers have to be in writing. In the life of your business, the kinds of contracts that you are likely to stub your toe on, in the formation of your business, you could see a partnership contract. Partnerships can arise by conduct, but it is much better to have written contracts with partners. Similarly, a joint venture, which is a type of partnership for a specific purpose, should be in writing. Buy-sell agreements, that's how if you have co-owners and you want to leave the business or sell your interest, how that relationship will sort out, those kinds of documents will be in writing. Your operating agreement is in writing for your LLCs. These are all contracts. You'll have employment contracts with employees. Employees can be full-time or part-time. You may want to have non-competition terms in your employment contracts. You may want non-solicitation provisions in your contract. So non-competition means they won't go into the same business. Non-solicitation means they won't steal your workers. And we've already talked about work for hire. So those kinds of employment and engagement agreements you're likely to encounter. We've talked a little bit about loans and liens. Those kinds of things can affect your intellectual property rights, and those are contracts. Deal documents are obviously contracts. So you have non-disclosure and confidentiality agreements, so you can share ideas and talk about whether you want to get in business with somebody. You have the difference between tangible and intangible, how you're going to deal with the rights in that scenario. If it's goods or services, you need to distinguish. And with goods, you may have product liability issues. What if the goods hurt somebody in service, or the services hurt somebody? All of these things have different kinds of issues. Right now, when we see shopping agreements where people want an exclusive right for a short period of time to go out and try to sell your idea or your product or your creative property, shopping agreements. Or you'll have option agreements where somebody options the right to acquire your rights under certain circumstances and for certain amounts of money. At another point in your careers and the arc, you'll have acquisition documents, contracts by which you acquire rights, and disposition documents, documents by which you dispose of rights. So these are all different kinds of contracts. As we've discussed, assignments need to be in writing. However, they can be after the fact. Licenses need to be or should be in writing. So the devil is in the details. We're now going to go through a bunch of different contracts provisions. I'm just going to point out some high points of these provisions. Some of them will seem repetitive because they are, but they're different approaches to handling similar topics. So remember I talked about the need for clear definitions. This first little group are definitions from non-disclosure agreements. This one is these are confidentiality provisions that primarily relate to back office kind of information, business plans, strategy, financial information. all of those kinds of things can be confidential information and can be protected by a non-disclosure agreement. In a different kind of confidentiality agreement, one which is more involved with creative properties, you see the kinds of things that are treated as confidential information. That's program and episode ideas, treatments, themes, names, titles, plots. It goes on, characters, characterizations, events and incidents, derivations, and so on and so on and so forth. Again, the drafting of, when people hand you documents that are not necessarily tailored to your particular business, you need to read them and see if something's missing. Is there something that's important to you that's not in there? Because once the ink is dry, the contract is signed and you're bound. We talked earlier about non-competition and non-solicitation, and I just wanted you to see what those look like. And also, this is kind of important. So we've got a situation where in Kentucky, every state has different non-competition requirements. Non-competition is considered a restraint on trade and is disfavored at law. In Kentucky, you can have up to 2 years. There has to be a reasonable time and a reasonable geographic limitation. There also has to be a business purpose for the restriction. And frequently that business purpose is that you've exposed that person to your trade secrets. And in order to protect them, you need them to not compete for a period of years. Similarly, you can see non-solicitation. That's, you just don't want people that you work with using your business as a grocery store for their employees and contractors. This is work for hire language, and it's pretty straightforward. But this is the kind of language that creates a work for hire. So acknowledges that the work that they've done has been created and is going to be created as work for hire, and acknowledges that the rights are owned by the hirer. Then you'll see the catchphrase, and you see this all the time, and that's because of the 9 categories. So many kinds of copyright protectable works cannot be work for hire that invariably you will see assignment language following work for hire language that says, so if it isn't a work for hire, then I'm assigning my rights. This is an assignment document. And I think it speaks for itself. But one of the important things I want you to see is that with a trademark assignment, you also must assign goodwill, because goodwill is in fact trademarks are the embodiment of your goodwill, and goodwill travels with the marks. Contracts obviously create obligations. Who's going to do what? Usually it's the artist will do something and the other person will pay the artist some amount of money for doing what the artist does. I think it's really important to define with specificity what that is. You can see that this one talks about the artist performing services to create a sculpture. This was little letter I. There were a lot more responsibilities. I just want you to see how we also carve out that that there are rights, that there are responsibilities that fall on the other side. Risk of loss. Contracts are about identifying risk and allocating it. So in this contract, the risk of loss is on the artist bears the risk of loss until delivery. After that, it's up to the acquirer. Similarly, the title provision is very important. You can see here that there's an acknowledgement that title to the physical sculpture passes, but the artist is retaining the copyright. This is a Vera waiver. Look at the bold capitalized words. Frequently in contracts, you'll see what's called conspicuous language. That's what this is. Some things are required to be conspicuous in order for them to be enforceable. Vera contracts do not have to be conspicuous, but they have to be in writing and they have to be signed. And this particular example shows that they don't want any mistakes. They want the artist to understand and to read the highlighted materials. In a slightly different approach to the rights of integrity, this contract acknowledged that the work might have to be moved or destroyed, and then provides how to deal with it. And in that case, they notify the artist, we have to move it, we have to destroy it. And the artist has the right, remember the moral rights are attribution and integrity. The artist has the right to remove attribution or to have the work destroyed. Here is a provision about credit and copyright notice. You need it in your contracts if you want it. I guess that's all I have to tell you. Clearly define the grant of rights. This one is appointing a distributor. Distribution is one of the bundle. This is a license to use marks, and you'll see that it refers to a schedule or an exhibit. So what this allows you to do, you'll see the schedule is going to define everything. The schedule is going to list which marks are licensed. It's going to define which licensed works are licensed. It's going to define what products are allowed to be made. It's going to define what retailers they're allowed to be sold to, and it's going to be attached to the document. Here's another grant of rights. This one is a right to reproduce. Remember the bundle, reproduce and just transmit. This is what that one's about. I have included a lot of skinny print from a very big contract that involves the theme park, the Harry Potter theme park, because as you can imagine, the lawyers that drafted that license agreement, which is about 70 pages long, defined everything down to who could breathe on premises. And but again, it speaks to how important well-crafted provisions can be. As we've discussed, approval of use of intellectual properties are required, and the next group are approval documents. So different contracts treat approval differently. I like to set up each kind of process involves different sort of major milestones. I like to set up approval steps at each milestone, give whoever has the right of approval a limited period of time to approve, and if it's not approved within that period of time, then it will be deemed approved. if you haven't heard back. These are the kinds of things that prevent fights later. This is also, if you're expecting to receive royalties, you need an audit right, and you need both an audit right of books, but you also need to be able to go on premises and inspect the manufacturing facilities. Sorry, my phone was ringing in the distance. You need to inspect manufacturing facilities and production facilities. Remember, in the trademark world, quality and rights go hand in hand. Here we go. This is another acknowledgement of ownership of the licensed property. This is all about quality control and approval and different approaches to how it goes on. This is, you can see, yet another kind of quality control provision. Here we go with capitalized terms again. When you sell a product, products have certain implied warranties, and that's a whole nother topic that we absolutely don't have time to talk about today. But warranties are promises about how a product or service will function and what it will do. That's merchantability and fitness for a particular purpose. And these particular warranties occur unless you disclaim them. And this is one of the kinds of terms which must be in caps. Disclaimers of warranties have to be in all capitals. Similarly, look down, it talks about how much shall be in no event liable for special, incidental, consequential. Anytime you're limiting damages, that has to be in caps also. So once again, here you go. Capitalized, no implied warranties. This is a provision that talks about how damages will be limited. Again, these are just things to think about when you're preparing your contract. But if you're going to have huge amounts of money at stake, think about it. This is a change order provision and how you want to protect yourself. Frequently, as a project goes on, the acquirer of the project results, these things, they grow like topsy. And we call them feature creep. You want to be very careful not to allow that without a change order, another kind of contract. And you want some kind of provision that says that until those change orders are signed, you're not doing any more work. And that's not a breach of contract. This is another provision about cooperation. And the reason that these cooperation terms are important is if you get into litigation, you need the cooperation, third-party litigation, you need the cooperation of your contract, the person with whom you're in contract. So in this case, this says that they'll sign documents. So for example, in a work for hire agreement, they may, or an assignment or a license agreement, there may be rights that you may need to sign later on to perfect your rights. Even after the contract is over, they're promising they're going to sign that. So if you have to clean up your chain of title, you can. Also, it's good to have people cooperate in terms of saying that they'll appear as a witness if you need them, and that they'll provide documents if you need them. This is force majeure, which got primetime play during COVID. Force majeure is a contractual provision that talks about how you're going to deal with delays that are beyond the control of the parties. Sometimes force majeure says that the contract will get extended for an equal amount of the delay. Sometimes it provides a very specific provision that if the delay is in excess of a certain amount of time, that the contract can be terminated. Notices, relationship of the parties. Remember, you don't want surprise co-authors. You don't, and you certainly don't want to be in a partnership or a joint venture. That you're not expecting. So that's what that relationship of the parties provision is about. And it says that no matter what we're doing together, this is not happening. We're independent contractors. We are at 7 o'clock. I want to talk briefly about all these, at the end of contracts, you have miscellaneous provisions. And I really just want to kick through those really quickly. You frequently see severability provisions. And what that means is that if somehow an invalid provision got into your contract, depending on how the severability provision is written, it can either be ignored or you can allow a court to what's called blue pencil it and rewrite it so that it's enforceable. Entire agreement provisions, that's so that only the contract and its 4 documents are considered, or its 4 corners are considered in construing the relationship. So any email that you wrote before, any advertisement that brought somebody to your door, those are not considered part of the contract. That's what that provision means. I do not like waivers of jury trials. I think juries are the last institution that can't be bought. Here's another set of general provisions. Similar kinds of things dealt with, but you can see now that you're starting to be familiar with different kinds of things, you can start to understand why these provisions are appearing in your documents. Similar, these are just more kinds of big, fat, fluffy, end of contract, miscellaneous provisions. And these relate to dispute resolution. I encourage a healthy dispute resolution provision. This one is from the Harry Potter theme park. Similar kinds of provisions where you require that you get on the phone first, that if you can't resolve it on the phone, you're going to meet in person. If you can't meet in person with your representatives, if you can't resolve it, then you're going to go to mediation. And then and only then can you go to court or arbitrate. Now, I have very strong feelings about arbitration as well. This is a Harry Potter agreement. They have an arbitration provision in this. I do not think that unless you are dealing with astronomical amounts, arbitration is worthwhile. You have to pay the judges. They can be excruciatingly expensive. Your taxes have already bought great judges. I don't really love arbitration for that reason. However, when you are dealing with internationals, arbitration can be very helpful because arbitration awards can be enforced internationally. Another force majeure, the interpretation provision, you'll read that periodically. Usually contracts are construed against the drafter. A lot of contracts will say both parties are drafters. It won't be construed against either of us. Okay, so here we are at parting thoughts. And I want to go through some of these things just sort of to wrap up and give you a way to think about what contracts can do for you in the big scheme of things. I want you to start by always looking at your contract and asking yourself, is this clear? If you do not understand what you are reading, it is not clear. If you have a question about what a word means, you need to know. You want to make sure that the parties are clearly identified. Do not use, trade names, use legal names. Definitional clarity, we talked about that. One word for a term. If a term is capitalized, that's called a term of art, and there should be a definition somewhere in the document. If there isn't, it needs to be in there. You want transactional clarity in your documents. And by that, I mean, I want your document to consider the entire arc of the relationship, the beginning, the middle, and the end gone wrong. Your contract should help you if something goes awry. Contracts set boundaries and they control expectations. And lots of lawsuits happen from erroneous expectations that are not met, that create disappointment, and then cause disputes. As we've discussed, you want to identify and allocate where the risk is. You want to build into your contracts ways to prevent problems. So designate a person with authority to make decisions and get the other side to too. Nothing is worse in an approval staged process than having to work through a committee and not have one person with authority. You need, like I said, approval stages with response times. If you have a termination provision, you may or may not want to allow for cure. I want to keep you out of court. I think cure provisions are helpful. Cure provisions can be whatever amount of time seems reasonable. Frequently, it's like 30 days, unless it's money. Money doesn't take 30 days to cure. If you haven't gotten your check, the cure provision should be like 5 days. Build in alternative dispute resolution provisions, build in agreements to sign in documents in the future, build in agreements to cooperate in third-party litigation, plan for what could go wrong, talk about insurance, think about force majeure. What warranties are you willing to give? What warranties do you want to disclaim? Think about indemnification, where the parties then promise that they'll defend the other in certain circumstances. It can be a wildly expensive promise. Read it carefully. Limit your damages if you need to. Try to use contracts to make litigation less uncertain. Arbitration frequently does that. However, I've already mentioned my concerns about that. Law fixes establish the state or jurisdiction which law will apply. We've talked about why that can be important. And a jurisdiction or venue fix is a provision that says, if we have a fight, you're going to come to Kentucky, or I'll come to New York and we'll fight there. So keep that in mind. Sometimes I've seen contracts that say that the law will be whatever, but will come to fight you on your turf or vice versa, depending. Can be, these are invariably flexible. All right, here we go. You need to call contracts for artists. The reason to call your lawyer and get it in writing. You'll only have problems if you make money or lose money. Agreements are romances. Takes 2 yeses to make a yes and 1 no to make a no. Negotiate and memorialize deals when you are still friends. A call is cheaper than a lawsuit. A contract is cheaper than a lawsuit. Lawsuits are like lobster pots, easy to get into, hard to get out of. Good fences make good neighbors, and contracts are fences. But don't forget, good neighbors also make good neighbors. So do your due diligence up front and try not to get into a transaction with a problem pill. I'll take any questions you have now.
Okay, Kyle, I'm going to start with the last question that was asked, because I think it was maybe in reference to one of your final points before you did your summary. It was just the words liquidated damages and question mark.
Okay. So liquidated damages are a provision that says that in certain circumstances, you will get X amount of money. That's what they rather, it sets a value to the damage.
Okay. I'm going to go. So there was very early on, there was a question from a Megan Bickle, and it's a circumstance, and this may be, let me see here. And I think she's talking a little bit more about copyright. So, but let me run through this. How much background do you have in guiding the use of copyrighted material by artists? For example, I'm currently utilizing image data mined from Google, often images published by the New York Times and similarly published. They're generally regarded as fair use until published. Do you have recs for procedure, points of reference, etc.? Thank you for your time.
Okay. I mean, fair use, what you need to do is lean on the good folks at LVA, and we'll do a whole program on fair use, because for me to answer a fair use question in a sound bite is almost impossible. Okay. A lot of things that people think are fair use are not. Fair use is a fact-driven inquiry that it's based on the use. Multiple factors are considered. I tell you what, Megan, I encourage you to give, if you want to ask me a question, you can give me a call at my office and we'll drill down a little bit. It's very fair use. It takes pages to do fair use, but we can do it, and LVA can bring it to you. Okay.
Well, that's a good thought. We often wonder what are going to be our next ones down the line, and there we go. We'll schedule that one. Maybe when the weather turns warmer, we'll have an in-person one. So let me see. Okay, here's a question about licensing. Can or should a lawyer negotiate licensing for an artist's image usage by a large corporation?
Absolutely. Look, bargaining, you want to level the playing field as much as possible. Don't bring a knife to a gunfight.
Megan also shared that kind of answered a question, but she might reach out to you. So here's one from Frank. He says, I own a painting by a famous French artist who was born in 1831 and died in 1900. It's been in our family for about 40 years. My brother would like a giclée, a copy printed on canvas. I tried to have a giclée made, and they would not make it unless I have a written letter granting such print to be made from the artist or his heirs. Is there a law I can show which gives me the right to have a giclée made for personal use?
Yes. Works so let's see if I can get this right. I don't want to get it wrong. Well, I'm not going there. That work is in the public domain, and the date of creation controls that, and I understand the concern of the giclée producer, because they can get sued for reproducing. Remember the bundle of rights, reproduce without authority lawsuit. But that's a silly one. There probably isn't a document from the heirs unless your family was tethered to them that you can get. I do think that maybe a nice little clip of a provision from the copyright statute that talks about how long copyright lasts, and maybe just a statement, a letter, an opinion letter from a lawyer that says this is in the public domain. That's the best I can do for you there.
Okay. Well, the only other question we had, and it was from Forrest Boone, who had to leave us, and he basically sums it up by saying he thinks he'll probably have to get in touch with you. It might be too complicated. But he's talking, but maybe there's a general observation you can make about. He's talking about a long-term sculpture project in which he owns the copyright, but there will be 3D prints of the sculpture made, and I guess he's wondering about how does that complicate controlling the rights.
It really doesn't complicate the rights. I mean, again, the tangible object and the intangible rights are completely separate in terms of how you deal with them. He can sell 3D printed tangibles without impacting any of the copyright bundle.
Okay.
I do want to just in parting say contracts are, like I said, they're much more than just a honey-do list. They really can be quite strategic in terms of planning, particularly about what could go wrong, and making what could go wrong go down a lot easier. So I commend them unto you.
All right. Well, thank you again so much, Kyle. This is, you know, they're scary. Things like contracts are scary, and because, as you've pointed out, there's so many different kinds of contracts and ways that they need to be employed. So, but there's no reason to be scared.
I have one other thing to say, and that is there are no bad questions. If you are reading a contract and you have a question, ask it, because don't be embarrassed. Don't think I should have known, I should understand. You have no idea how many times I read a contract and my client says, what does that mean? And I say, I have no idea.
Okay, there's a new question from Drew Pilmer that I think maybe came up as a result of that one discussion about the old painting. That if you are in possession of a valuable piece of art that you've inherited through your family, that might be by a relative, should you seek to have a contract, and I hope I'm getting this right, seek to have a contract protection before getting it formally appraised?
No, I don't think so. I mean, you're saying you have the work, it's in your family. Appraisal doesn't impact any rights. It just establishes value.
Well, an appraisal, you know, if you're working with a licensed appraiser like Christian Trabue, who I know does a lot of work in this area, and you know, that's a very professional relationship. But it doesn't necessarily have confidentiality exactly, but they're working with you as the client. You're paying them for their services, so that's a contract. So if there's any concern, I mean, I think that relationship, that professional relationship, would cover it.
Yeah, I think that's right.
Okay. Well, thanks everybody for joining, and thank you again, Kyle. We will
Thank
be
you,
posting
everybody.
on our YouTube channel probably within about 24 hours. So you can look for it there. You can just go to YouTube and type Global Visual Art, and you'll see a lot of wonderful programming there. The R series, interviews, all sorts of cool stuff. So please take the time to check that out. And everybody have a good evening.
Thanks for the opportunity. Have a good night.